Hi, my name is Gordon Hughes, and I'm going to be talking to you about the importance of non-disclosure agreements. Now, everyone is familiar with non-disclosure agreements, and you may well think there's nothing left to learn, and maybe that's the case. But the fact is, non-disclosure agreements are so common, and we're so familiar with them, that there can be a tendency to take shortcuts, and there can be a tendency to lose sight of the legal implications of what's in a non-disclosure agreement, and indeed lose sight of the objective of what we're trying to prove by having a non-disclosure agreement. And that's what I want to talk about, bearing in mind that non-disclosure agreements are, in one sense, the most important contract that your client will sign in very many transactions. So what I'm going to talk about is pretty much some basics, but also some recent developments. We'll talk about whether there's a difference between a non-disclosure agreement and a confidentiality agreement. Should it be an agreement or a deed? Are these documents necessary at all? Are they necessary on every occasion? What are we trying to achieve? What are the secondary objectives? In other words, what other things do we try to achieve at the same time as getting someone to sign a non-disclosure agreement? Should they be one way or reciprocal, and what's the difference and when does it matter? And ultimately, what do we mean when we even talk about confidential information? Starting with the basic one, what's in a name, I've seen people tie themselves up in knots trying to explain the difference between a non-disclosure agreement and a confidentiality agreement. The fact is, from a legal perspective, there's no difference at all. Call it what you like. Either way, what you're trying to achieve is a contractual commitment to keep certain information from getting into the public arena. Should it be an agreement or a deed? There tends to be this assumption amongst many that it's better for it to be a deed because it's more formal, more binding, more significant. That's not really true. Ultimately, whether or not you're going to have a deed or an ordinary agreement depends on whether or not there's consideration flowing in both directions. If there is consideration flowing in both directions, a contract, an agreement will suffice. It doesn't need to be a deed. And if you think about it, it's very rare that there won't be consideration flowing both ways, because it's very rare that you'll have cause a person will have cause to be giving information to someone else in exchange for nothing. There'll normally be some expectation of an outcome of having disclosed the confidential information in the first place. Therefore, there'll be consideration. Therefore, an agreement is sufficient. And it's relevant simply because the process for executing a deed can and often is far more complicated. Different jurisdictions have different rules regarding the formalities accompanying the execution of a deed, for example, whether or not a witness is required. And particularly in the time of COVID, executing deeds are accompanied by other rules, or maybe accompanied by other rules relating to the validity of electronic witnessing in particular. So my view is, if it can be an agreement, you're better off having an agreement and getting the job done. What happens if you overlook having an agreement executed? Is that the end of the world? Well, whilst it's highly desirable that an NDA is executed in appropriate circumstances, it's not necessarily the end of the world if one is not signed. And this is because the common law, or equity to be precise, recognises a confidentiality obligation in any event. If information is inherently confidential, that is not in the public arena, and it's imparted in circumstances whereby the recipient should realise that they are expected to keep it confidential and not to disclose it to a third party without authority, then common law protection will be available in any event in the absence of of a formal agreement or deed. That principle emerges from the landmark Australian case of cause, pay, be, whiting, burn, and the collector of customs. That then leads to the question, well, if confidential information is protected at common law, what are we trying to achieve by even having a non-disclosure agreement? What are the advantages? Well, the answer is that by having an agreement, by setting it out in writing, you can remove a lot of the grey area, a lot of the ambiguities that will otherwise exist at common law. So, for example, you can specify more precisely exactly what information it is that you are seeking to ensure remains confidential. You can remove any ambiguity over the question of whether or not that information was imparted in circumstances giving rise to an obligation of confidentiality. You can make it quite clear that that obligation does arise. You can specify a specific purpose, a limited purpose for which that information can be used, and you can place a time limit on it. You can specify that this information can be used by you for a specified purpose for a specified period of time, say 3 months. After that, it must be destroyed or returned. So in other words, you can frame the terms of the confidential disclosure far more efficiently by having the transaction reduced to a contractual undertaking. And the bottom bullet point on this slide, which is of particular relevance to our patent attorneys, is that a non-disclosure agreement is very important, certainly very useful in ensuring that there's no prior disclosure of a potentially patentable invention, because obviously prior disclosure will jeopardise the patentability of that invention. Non-disclosure agreements often are designed to achieve secondary objectives, some of which are more important, some of which are more appropriate than others. I'll just run through a couple. Intellectual property ownership. It's common for NDAs to refer to intellectual property ownership, and to a large extent this is fine. It's fine, for example, and appropriate, I think, for the NDA to emphasise that just because we're handing over confidential information in which intellectual property rights may exist, this cannot be taken to be in any way an implied assignment or unrestricted license to use that intellectual property. That much is uncontentious. What you have to be a little bit more cautious about, though, is the typical paragraph B of that clause, which will say that any intellectual property rights arising from the recipient's use of the confidential information will be assigned normally back to the discloser. Now, in many instances, probably a majority of instances, that will be appropriate, but it's not necessarily so. And all I'd say at this point is that it's something that you need to give consideration to, who in fact is the appropriate owner of IP rights arising out of the use of that confidential information. The answer might well turn on the purpose for which it's being disclosed. NDAs are often accompanied also by a non-compete clause, and that's fine and uncontentious and reasonable if what that clause is saying is that the confidential information can't be used by the recipient in order to compete with the discloser for a period of time. What needs to be kept in mind, though, is that the wider the non-compete clause becomes, the more problematic it might be to enforce it. And I think it's useful to bear in mind the fundamental well-established principle that a non-compete clause is prima facie void, is prima facie unenforceable, unless the court is satisfied that special circumstances exist which warrant that restriction being put in place. I've cited a case on the slide there of Tropiano and Raboni. It's not one of the better known cases, but I've mentioned it only because if this is an issue that you want to explore in more detail, that case gives a very cogent summary of what the relevant principles are. And one of the things the courts will take into account when you've got a non-compete clause in a confidentiality agreement is that restraint must be serving a useful purpose, an effective purpose. This came up in a case last year before the Supreme Court of New South Wales, Verrant and Sutherland, and it involved a confidentiality deed which a departing employee was required to sign by his employer. And it was a 12-month restraint on competing with the use of confidential information. The employee was inclined to ignore it. The employer was successful in obtaining an interim injunction initially for a period of 2 months. At the end of 2 months, the employer went back to court to seek a further extension of that restraint, and the court declined to grant it. Declined to grant it because it said really it was serving no useful purpose anymore. There was no evidence that the employee had taken hard copies of the information, the client information, which the employer was concerned about, and the court concluded that it was improbable that the employee could have committed to memory any of the important information, any of the relevant information like telephone numbers that the employer was concerned about. A case which obviously turned on its facts, but a useful reminder that restraint clauses must be reasonable, must be pragmatic, and must be serving a useful purpose. Otherwise, they're just going to be struck down as void. NDAs might often include a privacy clause, and that's often quite useful where personal information is contained in the confidential information that's being disclosed. Now, privacy and confidentiality shouldn't be confused. They're totally distinct concepts. But the privacy clause might be necessary to protect the disclosure for reasons other than simple confidentiality. The disclosure of personal information will have obligations, normally, under the Privacy Act as to how that information is handled. It'll have an obligation under the Australian privacy principles to keep the information secure and to ensure that it's used for restricted purposes. So it's quite appropriate where circumstances so dictate for the non-disclosure agreement to include a contractual commitment from the recipient to keep that information secure, for example, and to only use it for purposes that are consistent with the purposes which constrain the disclosure in the way it is permitted to handle personal information under its control. And then with increasing frequency these days, we find that NDAs contain a time limit. That is, this agreement continues for a period of, say, 5 years. I find these clauses can be problematic, principally because it begs the question, well, what happens after 5 years? And that depends on what the parties' intentions are and how they're expressed in the agreement. Are we saying that at the end of, say, 5 years, there are no longer any confidentiality commitments attaching to the confidential information? If that's what we're saying, then I think that is problematic. I see no reason why information should no longer be regarded as confidential simply because a period of time has expired if that information is still not in the public domain. If it's not in the public domain, it should remain confidential. And that leads to the second part of that question. what actually do we mean by saying that the confidentiality agreement expires? Are we saying that all bets are off and the information is free game? Or are we saying that the contractual commitment is expiring after 5 years or whatever period it is? The contractual commitments are expiring, but the common law commitments still remain in place. If it's the latter, then I regard it as an acceptable proposition, but it should be made very clear that that is the case, and that just because the contract has expired, it doesn't mean that the information is now automatically in the public domain. Those time limit clauses do need to be treated with some care. Should the agreement be one way or reciprocal? Well, it depends again on the circumstances. I'll just refer to my last bullet point on this slide, that mutuality can be a comfort or a hindrance in negotiations. It can be a comfort in the sense that it can sometimes be easier for one party to sell to the other party a particular confidentiality constraint. If you say, well, it cuts both ways. It's good enough for you, it's good enough for us. Therefore, there's no point arguing about it. But it can be a hindrance also, because if one party is of the view that the restraint should be only one way and that they shouldn't be giving a reciprocal commitment, then it can bog down negotiations on what should typically be a fairly straightforward negotiation to get the document signed. So if you're going to make it mutual, think about exactly what it is that you might be getting yourself into in terms of complicating negotiations. Then there's a question of how do we define confidential information in an agreement? And this is a situation where sometimes it's possible to be too smart by halves. What I've got on this slide here is a typical definition. I'm not being critical of it. Indeed, it might be one of my firm's definitions that we use occasionally. But it does have potential problems associated with it. This agreement, which someone has worked on at great length, tries to cover absolutely everything, as you can see from the wording. Inventions, discoveries, systems, techniques, marketing plans, pricing, financing, everything. It sounds great, but there's a danger that it can be so wide as to be meaningless. It's not really assisting the reader, it's not really assisting the court in identifying precisely what information it is that the parties are concerned about. And so before you have an all-encompassing, all-embracing, wonderfully crafted confidentiality definition, think about, is it achieving your objectives? Is it sufficient to actually pinpoint and ensure the protection of the precise information that it is that you are concerned about? And extrapolating that thought a bit, I've underlined a couple of items in this definition that can be problematic. One is the protection of know-how. Now, know-how is one of those expressions that if you look at the cases means different things to different people, means different things to different courts. And there are some forms of know-how that courts are reluctant to protect. Employee know-how, that is the skills an employee learns about how to do their job, at common law is not protectable, and therefore in a contract might be unprotectable as being too vague. Trade secrets are always thrown in there. There's been a lot of literature, a lot of discussion, a lot of case law about what the expression trade secret means. And again, you get different answers depending on different circumstances. Query whether the expression trade secret can mean anything more than confidential information owned by a business, and therefore whether those words are serving any purpose. If they are intended to serve a particular purpose, then you may have to define trade secrets separately as well. I've also underlined or highlighted in this definition the reference to intellectual property, and the fact that intellectual property is often thrown into a contractual definition of confidential information. And I think when that's done, where that's done, it's not correct, because most intellectual property is in fact not confidential. Most intellectual property is in the public domain. The fact that you own a patent, the fact that you own a trademark is in the public domain. It's not inherently confidential. It doesn't make sense to be telling someone that it's something which the existence of which they're not allowed to disclose. In some circumstances, it might have a place to play, but think twice before you just dump it in that definition, because it mightn't be serving a purpose. If you're a lawyer acting for someone who's asked to commit to protecting that information, you may well be entitled to go back to the disclosure and say, well, what are you actually expecting us to commit to here? There have been a few cases in recent times about what's protectable and what's not, both at common law and in NDAs. And I've just mentioned 4 cases on this slide, which I think all have an important message. The first one sends the message that just because you stamp a piece of paper commercial in confidence, as people want to do, that won't necessarily protect it at common law. It won't make a document confidential if it's not inherently confidential, if it's already in the public domain, for example. That was a decision of the AAT in the case that's cited there. But conversely, the absence of a label, the absence of a designation on a piece of paper that it's confidential, may be interpreted by a court in particular circumstances as meaning that it wasn't intended to be confidential, and therefore, at least at common law, will not be regarded as information that is the subject of a non-disclosure obligation, whether at common law or at contract. A label, nevertheless, going to the third case, can be contractually effective, even though it may not be effective at common law. So, for example, if you say in your non-disclosure agreement that this particular document may not be disclosed and must be treated as confidential, even though it's in the public domain, the fact that the recipient has given a contractual commitment not to disclose that information can be a binding commitment. And maybe at common law it will be disclosable, maybe at common law it's in the public domain, maybe people who haven't signed this non-disclosure agreement will be free to disclose it because it's in the public domain. If the recipient has given a contractual commitment not to disclose it, that contractual commitment will be sufficient, or has been held to be sufficient, to restrain that person from disclosing it to anyone else. And that was the decision of the federal court in the case I've cited there, the Korea Step case. And the other case of interest in recent times was the Stefanowski decision, where the recipient argued that documentation they received was not intended to be confidential, it wasn't imparted in confidence. It was the subject of password protection. And on the facts of that case, the court concluded that the fact that it was password protected was evidence that the discloser regarded it as being confidential, and therefore it should be regarded as confidential information, which was the subject of protection. So what all these cases are telling you is NDAs are very familiar documents. We all know them. You really need to read them and think them through and think what you're trying to achieve, and is the document actually going to achieve what you think it's intended to achieve. This last slide, which in the interest of time I won't linger on, simply talk about exceptions. I think probably you're all familiar with them. At common law at least, a document won't be protectable if it's information that's already in the recipient's possession, if it's in the public domain, if it's received from another source, if there's express or implied consent that it can be used in a particular way. those exceptions are all familiar at common law. They will also be exceptions whether they're expressed in a contract or not, depending on how the contract is worded. But equally, if the contract says that you may not disclose this information to a third party under any circumstances, this specific information, then even those exceptions won't protect the recipient if they want to disclose it. If they've given a commitment that they won't disclose information under any circumstances, then they will not be able to successfully argue that, well, it's in the public domain, so I thought it was okay. Now, that's all I want to talk about at this stage. Obviously, like the other speakers in this seminar, I'm happy to answer any questions if you'd like to forward them through to us. Otherwise, thank you. It's been nice speaking to you.
Great, thanks, Gordon. Hello, everyone. My name is Alistair Smith, and I'm a principal in Davies Collison Cave's patent group. Today, I'm going to talk about record keeping in respect of patent rights. Whilst record keeping is important for a range of reasons, the topics I wanted to focus on today include entitlement, specifically regarding inventorship and ownership, and keeping records of commercial activities for use as prior art or evidence of prior use. In respect of entitlement, this is effectively the process of identifying inventors and then ensuring rights to the invention are owned by the intended owners of the patent. In this regard, the inventors are individuals that have contributed to development of an invention, whereas the owners are entities that derive right to file applications from the inventors. Entitlement is important for a number of reasons. For example, if you miss identifying an inventor, and it turns out that another entity owns rights in the patent as a result of that inventor's contribution, this could lead to a claim of ownership over the patent. Additionally, patents can only be legitimately granted to owners that derive rights from the inventors, and patents can in some circumstances be revoked if the patent is not granted to entitled entities. Entitlement can also be expensive to correct if you get this wrong, with some jurisdictions requiring evidence and declarations to make a correction. Whilst in other jurisdictions, it can be difficult to correct inventorship, particularly post-grant, meaning this could be fatal to a patent. For these reasons, it is critical to identify inventors correctly and to ensure chain of entitlement is accurate. In dealing with inventorship specifically, it's important to understand that the assessment of whether an individual should be named as an inventor is a specific legal assessment and differs quite significantly compared to, say, assessing authorship on scientific papers. To be an inventor requires an individual to have contributed to putting an invention into practice in a manner beyond that which would be expected of a person of ordinary skill in the art. To assess this, it is therefore necessary to identify contributions made by any individuals working on an invention, and then assess which of these contributions meet the requisite threshold. Unfortunately, this process can be hampered by a range of factors, such as imperfect recollection or self-interest. For example, assessments may not be performed until some time after work commences on a project, sometimes months or even years after work began. And during that intervening time, individuals may have forgotten the exact circumstances that led to an invention being created. In some situations, companies offer rewards to employees if they are named as an inventor. And in this situation, an individual may attempt to overinflate their contribution on a project so that they can be named and receive a reward. To mitigate these issues, we recommend that individuals involved in developing inventions keep detailed records. This should include information regarding the research and development process and could include maintaining lab notebooks or a digital equivalent, recording meeting notes, saving email correspondence relating to the invention, keeping details of draft manuscripts or product specifications that are developed, or other relevant materials. In addition to this, Particularly where collaboration occurs, we recommend performing a formal inventorship determination. This involves identifying potential contributors and then seeking details of each contributor's input to the project, for example, by performing interviews with each inventor and then collecting corroborating evidence. Once this has been performed, a fact sheet can be prepared outlining a timeline of development of the invention. Contributors have the opportunity to review and then sign off on the fact sheet before the assessment is performed. This gives the contributors opportunity to challenge the facts contained in the fact sheet without necessarily understanding the implications this will have on the inventorship determination. The signed-off fact sheet can then act as future evidence as to why individuals have or haven't been named. Moving now to ownership. The default position is that when inventions are owned by the default position is that inventions are owned by the inventors unless there is an overriding transfer of entitlement, such as by way of an assignment, contract, or even an employee-employer relationship, where the employee is paid to invent, or at least there is an expectation that they will invent as part of their job, or where the employee owes a fiduciary duty to the company, such as if the employee is a director. Even where these requirements are met, some countries require written proof of entitlement, and so we advise that written documents are prepared where possible. In this regard, this is particularly important as if evidence of entitlement is lost or doesn't meet requirements for registration in some jurisdictions, obtaining signatures from an inventor at a later time can be problematic, particularly if the employee is no longer employed by the organization or is otherwise unavailable. To mitigate these issues, we generally recommend ensuring inventors are aware of ownership obligations, including the potential need for them to execute documents, sometimes even years down the track. This avoids awkward questions when assignment documents or other declarations are sent through at a later time. We also recommend ensuring all contracts with employees or contractors have specific IP ownership clauses, and that executed copies of such contracts signed by both parties are stored securely in the case that these are subsequently required. Additionally, we generally recommend obtaining confirmatory assignment documents as soon as possible, with these being in written form, physically not electronically signed by both parties, so that these can be used for recordal purposes if necessary. Moving on to commercial activity records. These can be important in providing evidence that can be used for invalidating patents or providing a defense to patent infringement. For example, records could include details of published activities, which can form prior art relevant to the novelty and inventive step of a subsequently filed patent application. Alternatively, records could include details of internal activities, such as internal research and development, which could be used as part of a prior use defense. In the case of prior art, this refers to anything published predating a patent application, which could be relevant to the novelty and inventive step of the patent application. Publication can be of any form and may include published documents such as patent applications, scientific papers, websites or brochures, but can even include conference proceedings, oral presentations, or public use of the invention. Whilst published documents such as scientific papers or patents can usually be easily retrieved at a later date, typically associated with some form of evidence of publication, such as a date in the case of a patent application or a publication date of a scientific paper. Some information, such as oral disclosures or websites, can be more problematic. For example, in the case of websites, whilst archive engines such as the Wayback Machine can be used as evidence of a website's content, as Liz will discuss later on, there are limitations in how and when this evidence can be used, and so it can be desirable to keep independent records. In the case of use of the invention or all disclosures, it is useful to keep details of the nature of the disclosure, the time and date on which this occurred, and details of any individuals that were present, in case these individuals are later required to act as witnesses to the content of the disclosure. We therefore recommend keeping records of what is published and, where possible, proof of publication. In the case of software, this can present its own challenges, so much so that one client I acted for previously kept a suite of old computer systems with their original operating systems, unupdated of course, and copies of their own and competitor software. This allowed them, where necessary, to load that software and review the content of the software, so they could use this as evidence for software features that had previously been implemented in their field. For similar reasons, it can be useful if companies keep other publications that are relevant in their field, such as brochures of competitors' products, trade journals, and other similar materials. In the case of prior use, this refers to exploitation of an invention that arises prior to a third party seeking protection on the same or a similar idea. In this instance, if the exploitation occurred in secret, this is not prior art and cannot be used to invalidate a subsequently filed patent. Nevertheless, there is a general principle that a patent cannot be used to stop you doing something that you were doing before the patent application was filed. And so this can be used as a defense to infringement. To rely on this, the activities, such as internal development of a product with a view to commercializing that product, must have occurred before the prior patent application priority date. And activities must be continuous in the sense that you couldn't start research on a product and then leave this for a period of time, such as a few months or years, and then recommence trying to commercialize that product after the patent application has been filed. It is notable, however, that temporary stoppages, as may occur, for example, during a global pandemic, would be permissible. Additionally, knowledge of the invention must not have come from the patentee. So in other words, you can't take a disclosure of the patentee and then start work based on this, and then rely on that as a prior user defense. In this instance, it is important to keep records of what activities are being performed in preparing for commercialization. This could include records of R&D that is performed, contracts with third parties, such as design contracts, supply contracts for materials or component parts that are used in building the product, or anything of that nature. This could also include internal email correspondence, grant applications, market research, or even physical prototypes of a product that had been developed. I had one client that was needing to rely on a prior user defense and fortunately had kept multiple iterations of prototypes they developed over a period of time, together with purchase orders for materials that were used in development of those prototypes. And that was fortunately enough to provide evidence of prior use, which allowed them to defeat a challenge by a third-party patent. It's important to note, however, that prior use defenses are jurisdictional. And so where activities span different jurisdictions, it's important to make sure appropriate evidence is kept for each jurisdiction. That's all I wanted to talk about for today. So I hope this information has been useful. And of course, I'm happy to answer any questions at the end of the presentations. In the meantime, I'd like to hand over to Taryn, who will now present on trademarks. Thank you.
Thanks, Al, for the introduction. As mentioned, and following on from Al's presentation, I'll be discussing the importance of record keeping and the role that evidence plays before the Trademark Office. So the primary points that we'll cover off today include: when is evidence required before the Trademark Office? What kind of evidence is required? What happens if you don't have the right or enough evidence? And whether evidence requirements are the same or different in New Zealand. So this presentation will focus on why it's important to keep accurate business records by illustrating when a business may need to produce this evidence before the Trademark Office, either to secure a trademark application or to maintain a trademark registration. So there are a few instances where evidence may be required, including during the prosecution of an application in order to obtain acceptance and eventually registration. If a trademark application is opposed before it's registered, or if a business opposes a non-use application that's filed against its trademark, or if that business files a non-use application against a third-party mark. So for example, to have it partially or fully removed from the register in order to secure registration of its own mark. In Australia, evidence must be provided in a declaration with supporting exhibits, and it does not need to follow the rules of evidence. It's also not necessary for the evidence to be presented in a statutory declaration, which requires a witness. I note that this presentation is limited and we will not consider evidence presented before the federal court, for example, in infringement proceedings. For the purpose of today, we will only focus on evidence before the Trademark Office. So turning now to when evidence is required during the prosecution of an application. Once a trademark application is examined, there are a number of grounds under which acceptance of that application can be objected to, and evidence may be required to overcome those objections. A Section 41 objection will be raised if a trademark is considered to be descriptive of the relevant goods and services that are covered by that application. So for example, if you try and register the real estate guide for real estate services, you'll likely receive an objection on the basis that any business which operates within the real estate space should be able to say that they are the real estate guy. To overcome this objection that the trademark is not distinctive, it's possible to provide evidence of use which establishes that your trademark has a strong enough reputation in the market such that when consumers see the trademark, they only associate it with your business. To establish this, it's necessary to show that the business has a high level of revenue that's associated with that trademark and that the business spends a considerable amount of money on advertising the brand. So business records of sales, profits, marketing spend for as many years back as possible will be critical in trying to get this sort of application over the line. In addition, evidence that third parties refer to the trademark in association with the business is also great. This can be presented in the form of articles or blogs that are written by others, which discuss your business and also mention the relevant trademark. So keeping a copy and record of each instance where your business is mentioned in the media or by a third party will be very helpful. We suggest keeping a PDF of the document, just in case the website link is deactivated in the future. And creating a PDF is also really helpful, as the date of use can be seen in the date of creation of that PDF document in the document's properties. So the amount of evidence required to overcome 41 objection will depend on how descriptive that mark actually is. So there's two levels of objections, either 41.3 or 41.4 objection. For a 41.3 objection, this means that the examiner considers that there's no inherent adaptation to distinguish the business's goods and services from those of other traders. Only evidence from before the filing date of the application and from Australia will be accepted. Evidence of overseas use can be given as an aside to the main evidence of use in Australia, but it won't be of itself convincing. For a 41.4 objection, this means that the examiner considers that there's some inherent adaptation to distinguish, and so evidence from before or after the filing date of the application will be accepted, as well as evidence of overseas reputation. Another objection that could be raised during the prosecution of an application is a Section 44 objection. So this is raised when there are prior applications or registrations that the examiner considers to be either substantially identical or deceptively similar to the business's trademark, and the goods and services are either the same, similar, or related. If the business has used the trademark since before the priority date of those prior marks, then the business has an opportunity to present evidence of this prior use. It's also necessary to show that the trademark has been used continuously since the date of first use up until the filing date of the application. So print or online ads that have a date stamp are helpful in establishing this prior use, as well as excerpts from the Wayback Machine, which is an archive website, showing use of the trademark on the business's website from as far back as many years as possible. So to overcome an objection of this nature, you don't need a lot of evidence to establish this prior use. However, the evidence that you do present has to be dated, which establishes that the use is since before the priority date of that prior mark. If the business has only commenced use of the trademark after the filing date of the prior mark, then it may still be possible to achieve acceptance by presenting evidence of honest concurrent use. So there will need to be substantially more evidence in this case to enable the examiner to determine that the parties can coexist on the trademark register as they have already coexisted in the market. So evidence of social media pages which show the number of followers that the business might have, how many customers are in their database, the extent of marketing expenditure, and any other indicators which show the magnitude of reputation of the trademark will assist the business in overcoming an objection of this nature. So while in most cases, a business should only protect its mark for the goods and services that it actually provides, it is possible to obtain a defensive trademark if the trademark is so well known that use of the mark in relation to any other goods and services could cause confusion in the marketplace. So for example, Kellogg's has a registration for water and non-alcoholic drinks, even though this is not a product that they actually sell. To achieve a registration of this nature, an incredible amount of evidence which shows the level of reputation of the trademark will be necessary. Of greatest value in a case like this will be evidence of revenue and marketing spend, as well as market recognition. We'll now consider when evidence may be required for opposition purposes. So once a trademark is accepted for registration, it's advertised for a 2-month period, and this gives third parties an opportunity to oppose registration if they choose. So if an opposition is received, it may be on the basis, for example, that the marks are too similar, the applicant is not the owner of the trademark, the application was filed in bad faith, or for quite a number of other reasons. Part of the formal opposition process that you go through with IP Australia, there's 3 different rounds of evidence where the parties either present evidence in support or in opposition of registration of the relevant trademark. So having evidence that shows how and why the business chose a particular trademark, for example, email correspondence with the branding and advertising agency, as well as evidence of the date of first use of the trademark, particularly if this use was quite a while ago, may help in overcoming some oppositions. If there's been a bad faith claim or an allegation of potential confusion in the marketplace, evidence of prior discussions with the opponent may support your position that the opposition is baseless. So keeping all email correspondence, evidence of posts that they've maybe made on social media or other social media platforms, or file notes that you have of conversations with the other side can all assist. The quality and relevance of evidence is also very important in opposition cases. A party could present a mountain of evidence, but it could still lose if that evidence is not relevant or if it doesn't substantiate their argument. Once a trademark has been registered for either 3 or 5 years, depending on the filing date of that application or registration, it becomes vulnerable to removal. So if there's no evidence of use or some or all of the goods and services covered by that trademark in the preceding 3 years, the trademark can be fully or partially removed from the register. Filing a non-use application is a tactic that's often used when a trademark application receives an objection on the basis of third-party rights. So rather than arguing against the objection, one option is for the applicant to file a non-use application against that prior registrar to try and have it removed, because once it's removed, it's no longer a problem. Evidence of use in respect of all of the goods and services will be necessary to overcome a non-use application. If there are holes in the evidence, though, For example, there's no evidence which shows use of a particular good or service. The examiner may decide to remove just those goods and services from the registration, allowing the rest of the registration to remain. That said, the hearing officer does have a discretion to maintain a registration, even if no evidence can actually be provided. So keeping dated records of print or online advertisements, which feature every single good or service that's covered by the registration, is critical in overcoming a non-use application. The evidence must also be within that nominated period, which, as mentioned, is 3 years prior to the filing of the non-use application. So if the business has evidence of use, but it's outside of these timeframes, the examiner may still refuse to consider that evidence. So in summary, the list that I have on the screen there are the types of business records that we suggest keeping in the event that you're either trying to secure trademark registration or if your trademark is challenged for any reason. So when the trademark was first used and the circumstances of adopting that trademark, how you sort of came up with the trademark and the sort of thought process behind that, the length of use of the trademark, location of that use, whether it's state-specific, national, international, examples of use of the trademark as applied to every good or services covered by the registration, the number and names of all distributors and sub-distributors that you have, the total volume of sales attributed to the trademark for each year of use, the total revenue attributed to the trademark for each year of use, marketing spend for the trademark for each year, and then examples of the trademark dating back as far back as you can. So this can include print and online advertisements, social media posts, brochures, any sort of marketing collateral, or photos, for example, pictures of you presenting the trademark at trade shows. Details of social media pages which feature the trademark and also show the number of followers can be really helpful. Or if you're looking at YouTube, the number of views of any particular video. And then examples of any actual confusion in the marketplace. So this would only really be relevant for opposition purposes. So if the business decides to oppose a third-party mark on the basis that there could be confusion in the marketplace, having actual examples of confusion will greatly assist in opposing that third-party mark. The critical thing to remember, though, with evidence is that it must be dated to be considered. If there's no date on the record, it's likely the examiner will not accept it as evidence of use of a trademark on the date indicated. So merely naming a document as having a date will not be sufficient. And as previously mentioned, one great thing with a PDF is once that PDF document is created, the document is given a creation date in its properties, and this can be used to establish use on the date nominated. Okay, so what happens if the business does not have sufficient or the right type of evidence? Unfortunately, trademark rights can be lost. So when prosecuting a trademark to have it accepted and eventually registered, if you can't provide evidence that the mark has become distinctive, or if you don't have date stamped evidence to show prior use or honest concurrent use, it's possible that your trademark may not be accepted for registration. From an opposition perspective, if you're not able to, you may not be able to overcome an opposition with a third party, which means that your trademark may not be accepted for registration. If your trademark has been challenged on the basis of non-use, if you can't show that you've used your trademark for the goods and services covered during that relevant period, it's possible that you could partially or fully lose your registration. So what about New Zealand? With New Zealand, it's critical to understand that evidence is examined at a much higher standard, and evidence that may be acceptable before IP Australia may not be accepted before IPONS. The first thing to note is that the rules of evidence do apply before IPONS, which is different to IP Australia. This means that all evidence must be presented in a witness statutory declaration, And if the evidence does not meet the necessary requirements, it will be deemed inadmissible and may not be considered by the commissioner. So in practice, this generally means no opinion evidence, no submissions that are presented as evidence, no irrelevant evidence, and no hearsay. So in summary, keeping records are critically important to obtaining and maintaining trademark rights. So setting up a monthly or quarterly system where you save a PDF of all news articles, blogs, or any sort of third-party mention of your business can help ensure that records are kept at the time of trademark use. It's important to keep a record of all print or online ads and links to the same. With links as they can expire or be deactivated, it's really important to create a PDF of that information presented that features in each link. A lot of evidence is now available on a business's Facebook page or other social media pages. So periodically saving your Facebook profile so that there's a record of all those posts is really helpful. If possible, we suggest working with your IT team to periodically save a record of your website pages, just in case anything that's posted at a particular time is relevant in the future. Of course, you can use the Wayback Machine, which Liz will talk about in greater detail in the next presentation. But it's good to also have your own sort of backup and records of your websites over a long period of time. It's critically important that the evidence is date stamped, as mentioned. Social media posts are really good for this because they're created at a point in time, and therefore there's a date that's nominated to each post. That's it for me. Thanks, everyone. I will now pass over to Liz, who's going to discuss the Wayback Machine. Thank you.
Thank you, Taryn. Hi, everyone. My name's Liz Lawson, and I'm a lawyer in our Brisbane office. You've heard from Gordon, Alistair, and Taryn about the importance of record keeping, and you may have been thinking, well, when it comes to records of how a website looks, I don't really need to keep any records because I can always rely on the Wayback Machine. Well, to some extent, that is true. The Wayback Machine can be very useful, but it has its limitations. And that's what I'm going to talk to you about today. I'll first of all go through what the Wayback Machine is and how it works. Then I'll talk to you about how Wayback Machine evidence can be used in the Trademarks, Designs and Patents Office versus the Federal Court, because the approach in those jurisdictions is quite different. And then finally, I'll finish off with some take-home points so that you hopefully don't find yourself in a situation where you've relied on the Wayback Machine evidence to your detriment. So what is this Wayback Machine? Well, you find it at the archive.org website. It's also known as the Internet Archive, which is an apt name because it's a digital library of internet sites. So you can use it to find how a particular website looked at a particular point in time. And it's really very simple to use. You just type into that little rectangular space there, the website address that you're interested in. So if we do that for our website, davies.com.au, you type it in there and then you click Browse History. Then up comes this calendar and you'll see all these black marks which indicate that the Wayback Machine captured screenshots of our website on all of those dates. And you can see that the dates on the far left, I think it's 97, and the Wayback Machine actually started in 96, so it's nearly over a quarter of a century old now, which seems amazing. And so then if I click on one of those black areas in that first calendar, up comes another calendar and some of the dates are bolded. And so what I can do is click on one of those and start surfing an archived version of the web. And you'll see there, I took a screenshot of one of the pages of our website way back in February 1999. As to the mechanics behind it, that archive data, those digital copies, are compiled using software programs known as crawlers, and that surf the web, and they automatically store copies of website files as they exist at that point of time of capture. When it comes to matters in the Trademarks, Designs and Patents Office, how a particular website looked at a particular point in time can be really important. And that might be from the perspective of protecting your own IP or trying to stop someone else from getting their IP registered. If we think back to what Taryn just spoke about, it might be that someone has opposed your trademark application because they think that they started using the name before you did. And you're sure you got in first. So you think, I know, we used the name on our website really early on. I'll go and have a look at the Wayback Machine to try and find evidence of that. Well, the good news is that in these jurisdictions, you can use the Wayback Machine to verify the publication date of internet documents. Plus, in these jurisdictions, the rules of evidence don't apply. And that means it's really quite simple to put it into evidence. All your attorney would need to do would be to go through those steps that I did in relation to our website and prepare a declaration which explains those steps that they carried out, and then annex screenshots of the websites in question. But even in these jurisdictions, there are limitations that I'd like to make you aware of. Firstly, the timing. It's not as though these crawlers come along and take a copy of every page of every website every day. They do it when they visit that website, but that doesn't happen every day. So that's no good if you find yourself in a situation where, for example, you've rebranded your business on the 1st of January 2005, and you need to prove that's when you started using your new brand, but the crawlers didn't come along until June that year. So in those circumstances, you wouldn't be able to rely on the Wayback Machine evidence to prove that you started on the 1st of January. Another limitation is the content. It doesn't always have every page of every website. Images can be left out, as can links. So that can be problematic. There might be a particular logo of a trademark that you want to make sure that you can get from the Wayback Machine, and it could be that it hasn't been captured. Not every website is captured. I use the Wayback Machine quite frequently, and I've been trying to think, has that ever happened to me? If it has, it's certainly been infrequently. So I think most websites are captured, but it's possible to opt out. And the last limitation that I wanted to mention was that you can't use a negative result to prove a positive. And by that, I mean that if, for example, you wanted to prove that a particular website didn't exist in 1998, and you go onto the Wayback Machine and, oh, great, the first capture is not until 1999. Well, you can't use the fact that the first capture wasn't until 1999 to prove that it didn't exist in 1998. So there are some limitations. Now in the federal court, as I said, the approach here is quite different. And when you might find yourself in the federal court is if you're trying to enforce your IP because someone else has infringed it. It's also in the federal court where challenges to the validity of IP are litigated. And another thing is if, for example, there's been an opposition in the Trademarks Office or in the Patents Office, and the decision's been handed down and that's appealed, then that appeal will be to the federal court. The overall message I'd like to convey here is that whilst there are 2 recent federal court decisions in which the judges commented that Wayback materials, they're likely to be a reliable indication of how a particular website looked at a particular point in time. And these 2 judges allowed the Wayback Machine evidence in. So they've said, 1, we think it's probably reliable, and 2, we're going to admit it into evidence. even though that's occurred recently, the message I want you to take home is that it's not straightforward to get Wayback Machine evidence admitted in the federal court. And another thing to note is that the Wayback Machine evidence in these two matters, it wasn't crucial to the overall outcome of the decisions. So just because it has been admitted in the federal court doesn't mean that it will be the next time the question is before the court. And the reason for this is essentially because in the federal court, the rules of evidence do apply, unlike in the office. And what this means is that with some exceptions, if evidence is hearsay evidence, it's not admissible. So you might recall in the previous slide, I said it's pretty easy to get Wayback Machine evidence into the office. You just have a declaration explaining the steps that you undertook on the Wayback Machine to take screenshots of those particular sites. Well, that won't do in the federal court because that's hearsay evidence. But as I mentioned, there have been these two recent federal court decisions in which the Wayback Machine evidence was admitted. In one, it was third-party websites, so websites of clothing retailers who weren't actually parties to the litigation. And in the other one, one party was seeking to put in Wayback Machine evidence of the other party's website, that is the other party to the litigation. So I'll just run through the sorts of factors that might help you get your Wayback Machine evidence in based on these two recent decisions. And the first requirement is to actually obtain evidence from someone who works at the Wayback Machine at Internet Archive in the US about how it actually operates. And that's important because all this digital copying that the software does is done automatically. It doesn't involve any human input. And in those circumstances, it can be argued that it's not hearsay because hearsay requires a representation by a person. Now, that argument was run in one of those two decisions that I referred to, and it succeeded. I should add here too, it's not terribly difficult to get that evidence. You might be thinking, oh gosh, getting evidence from someone in the US, that sounds complicated. But the Internet Archive's asked quite frequently for this sort of evidence because it's relevant to so many court cases. And so they have a pro forma affidavit. It costs $1,000 US. One thing to be aware of in our recent experience is that there can be a delay in getting it because of the COVID situation. Another thing is that they tend to have the same person provide the affidavit, and they're not a computer engineer. And ideally, you'd have a computer engineer who has very good first-hand knowledge of how it operates. But nevertheless, it's important to get hold of this Wayback Machine evidence from someone who works there explaining it. The next point here in the federal court is ideally try to limit the pages of the websites you want to get into evidence to ones that record the activities of the business rather than those that say, how wonderful the business is. And that's because it's more likely that those will be allowed in as a business record. And that's an exception to the hearsay rule if it's a business record. So what this means in practical terms is that pages of the website which set out the product name, price, a description of the product, that sort of information, they're more likely to be allowed in under this exception to the hearsay rule rather than, say, the About Us page. And finally, it's good to have other evidence which supports what you're trying to assert in the Wayback Machine evidence. Something independently of the Wayback Machine evidence that essentially says the same thing. Because in those circumstances, the judge may exercise their discretion to allow that evidence in, even if there is some admissibility problem. They might say, oh, look, it probably is hearsay, but they have that. They can then exercise their discretion a bit more readily. And the other party may have difficulty establishing that it would be prejudiced if the evidence was allowed. So where does all this get us? Well, number one, the Wayback Machine evidence, there's no doubt about it. It can be really useful, particularly in the office. Secondly, yep, it's harder in the federal court to get it admitted, but not impossible. It's happened recently. So what can you do? I guess what I'd like to convey is, because you don't know in which jurisdiction you'll end up, or, if the particular page of a website you want is missing from the Wayback Machine records, as far as possible, set yourself up so you don't have to rely on it, or so that you have other evidence which is consistent with the Wayback Machine evidence, which really means keep those good business records that Gordon, Al, and Taryn have told you about. To do this in terms of your own website, I'd recommend you keep a good record of how your own website appears throughout the life of your business. So that means if you rebrand, make sure you have a record of how it looked before the rebranding, the date of the rebranding, details of how it was rebranded, and then a record of how it looks post the rebrand. Make sure you've got the contract with your website developer, which would, set out clearly the date when the rebrand happened and what they did. It might seem like quite a bit of work now, but those records could be crucial if you find yourself in a dispute down the track. Likewise, if you add a page to your website or you make some other change, ideally have a record of what that change is and the date that it was made. If you're thinking to yourself, oh gosh, I make changes all the time, that's not practical, well, perhaps you could make a record periodically of your website. And I should say that these comments also apply to your other marketing material and records in general, not just your website. In terms of third-party websites, of course, it's a bit harder, but what I would suggest is if you do see some conduct which you think, for example, might be infringing your IP, take a screenshot of that straight away. Make sure the date is included, you've got the date saved, and save that. Then send it to your lawyer to see what they think. It may be that they say, look, this looks like infringement, and they'll arrange to buy a sample of the product then to confirm that. That's all from me. I hope that's been useful.